Eviction is really a two-step process. You can think about it. First, the landlord has to end the lease or terminate the lease. Then, if possession has not been granted at the end of the lease term, or when the lease is terminated, if the tenant does not vacate the property voluntarily, then the landlord files an eviction action to regain possession of the property. But you always have to terminate the lease first. And what do you have to do to terminate the lease depends on why the lease is being terminated. If you're on a month-to-month rental situation, you have to give a 30-day written notice that the lease is not going to be renewed, for the next 30-day rental term. If the lease is being terminated for non-payment of rent, you have to give that 5-day notice either in the lease or as a separate notice if it's not written into the lease that we talked about earlier. So you have to give some sort of notice as to, and it depends on why the lease is being terminated. Then if the tenant does not vacate the property, you would file an eviction action in the magistrate court, and the magistrate court will issue what's called a rule to vacate or show cause. The magistrate's constable, typically the constable, will serve that rule to vacate on the tenant. The rule requires personal service. However, if the tenant cannot be located after 2 attempts, then it can be mailed to the rule to vacate or show cause can be mailed to the tenant. And the tenant will have 10 days to request a hearing. The magistrate can hold a hearing. If the tenant loses, the magistrate will issue what's called a writ of ejectment, and the tenant can be forced to move out, and the sheriff can just physically displace, put the property outside if that doesn't happen. So just to get into a little bit more detail, the non-payment of rent, we talked about how the landlord has to give the 5 days written notice unless it's written into the lease, and it has to be given once per lease term. Breach of the rental agreement often has to give, the landlord often has to give a 14-day notice that the lease will terminate. And if the tenant does not fix the problem, so South Carolina is what's considered a right to cure state for most things. Cooking meth on the property, you don't get a 14-day right to notice on that. But for most things, you do have a 14-day right to cure. So a noise complaint, an unauthorized guest, things that are not really threatening the health or safety of the premises and things that are not otherwise illegal, get a 14-day right to cure before the landlord can file an eviction against the tenant. So that 14-day notice should say something to the effect of, we've noticed that, or landlord has noticed that you've been doing X, Y, or Z that violates this provision of the rules or the lease agreement. You have 14 days to, you should either not do that again, or 14 days to, repair the hole that was put in the wall, something like that. And if you don't, we can seek to have you evicted. And then after that, if the repair is not made or the issue is repeated, the landlord can move forward with eviction. So in South Carolina, the lease can end and nobody is required to renew it. And at the end of a lease term, if a lease term is spelled out in a lease, say for example, 1 year, the lease term ends automatically. Now, if you're on a month-to-month situation, there's a statute that says that lease term renews until it's terminated, but it's different for longer lease terms. Those lease terms end at the end stated in the lease, unless it's been renewed. So it's a little bit different treatment, and the landlord does not have to give a notice to terminate a lease where the end of the lease term is specifically stated in the lease. Now, if the lease term ends, let's say it's a year-to-year lease starting out, and the lease is not renewed, but the tenant keeps paying and the landlord keeps accepting rent, and we're 3, 4, 5 months down the road, the law would treat that as a month-to-month lease at that point. So, of course, if the tenant abandons the property, the landlord is allowed to terminate the lease. And in the case of abandonment, if it's really true abandonment, the landlord does have a right to retake the property without going through the judicial system. But generally speaking, the landlord does not have the right to a self-help eviction, which is what it's called when the landlord unilaterally regains possession of the property without judicial process or approval.